Family law expert on the Ask the Expert show. Attorney Tina Lewert is a board-certified specialist in marital and family law. Attorney Lewert is committed to obtaining the best resolution for your divorce or other family law case by consistently providing skilled representation, expert legal advice, and personal attention. Attorney Lewert has developed an excellent reputation for providing effective divorce and family law representation in Boca Raton and the surrounding communities. Lewert Law Offices offers legal advice and representation in a wide range of family law matters, including divorce, child custody, time sharing and visitation, child support, alimony, complex asset distribution, post-judgment modifications, and paternity actions. For expert representation in all aspects of divorce and family law, contact Attorney Tina Lewert today at 561-544-6861 or visit www.lewertlaw.com.
And we're back. God, I love today. First, we help you with your taxes, and now we're going to help these people out there that might be thinking about going through a divorce, or they're in the middle of a divorce. Maybe they're not happy with their attorney. But we have attorney Tina Lewert, board certified. I got to say that because there's not too many board certified attorneys in the whole state of Florida. And so I can say she's an expert.
I'll just let you talk the whole time.
No, you're an expert. And today we're going to do it a little bit different. We are going to, I took a bunch of questions from like the last 3 months and put them all together. So I'm just going to fire questions at you today.
Oh, boom. Okay. Uh-oh.
You don't even need to know what these questions are because you're going to,
is there like a timer or like a, is there a buzzer I need to hit?
Simple things like, I've been thinking for the last 30 years about getting a divorce. I mean, they're simple questions.
You and everyone else.
Wow. How's business?
It's we
don't want it to be good, but
exactly.
we do.
I know. I'm afraid to say it's good, but yeah, it's busy. I mean, especially in, I guess, this area of the country.
Yeah.
I think it's I have calls all the time for different things, and a lot of people, like you said, actually, you kind of hit on something. Will call me and say they're thinking about it and contemplating and have questions, before and all that. So I get a lot of phone calls where I'll talk to somebody or I'll give them a consultation or they'll come in for a consultation, and then like months later, sometimes years later,
really,
yeah, I hear from them. So
really
when they're ready, pre-planning, which if you're thinking about it or you have questions, is not a bad idea. I mean, at least educate yourself. So that's I get a lot of those and try to help out. But
tell everybody a little bit about your practice. You practice in Boca Raton, but you cover all of Palm Beach and you do Broward.
Correct. So my office is in Boca Raton, and I practice primarily in Palm Beach County and Broward County. And I would say, maybe half and half, 50-50, or maybe a little more Palm Beach County. I'm right on that county line, obviously. So I have a lot of cases that are at that, we call it the South County Courthouse, the courthouse in Delray Beach. And then I have cases in the Broward County Courthouse, and then in the main courthouse in West Palm Beach. Every once in a while, I have cases all around the state. I've had cases, in other counties.
I remember that.
Sarasota, and there's one in Brevard County. I've been talking about that for probably a couple years. It's still going on. Anyway,
that's the one you told us about.
Yeah. So I specialize in family law, as you said. I'm board certified in that area of practice, which means that the Florida Bar designates me as an expert in the area. And like you said, there are only about 300 of us in the entire state out of 102,000 attorneys that are board certified in family law. You can be board certified in other areas of practice like criminal and civil trial and different things like that. But my focus is on these cases. My practice consists 100% of divorce and family law cases. So I handle divorces. We have child support matters, child custody matters. Seeing a lot of alimony cases lately and modifications of alimony, upward or downward. So we do a lot of post-judgment. I call them post-judgment, meaning after the divorce.
Did it?
The law did not pass. Correct. The governor vetoed. There's a alimony reform bill, they were calling it, and it had to do with not just alimony, but there were some other pieces of it which related to child custody as well. So the governor vetoed the bill.
Is that good or bad?
Depends who you ask.
Okay.
And I could argue
depends
good
what side you're on.
Yeah. It does for the purposes of any given case. I could argue both sides of it. The people that were in support of it were saying, yes, we need to do away in Florida with what we call permanent alimony. We do have permanent alimony. There's in longer term marriages, 17 years and more right now, there's typically a presumption of permanent alimony, meaning alimony for the rest of the recipient's life, or until, they remarry. Or until there's a modification, because any number of reasons or grounds could arise where that gives rise to a modification. So, a lot of people don't like that permanent alimony phrase, and the idea was that one spouse shouldn't get to be supported by the other spouse because they happen to have been married to them at one time. The other side of the coin will say, well, there are situations where permanent alimony might be totally appropriate. Like if you have a spouse getting divorced in their 60s and they haven't worked in 30 years and they're unemployable, and how are they going to get a job to completely support themselves at this point in life? Or if you have a spouse who's disabled. I mean, there were exceptions built into the bill, but so in the end, however, the governor actually vetoed it because it had to do with the other piece of it, the child custody piece, which was the presumption. They wanted to create a premise of 50-50 time-sharing visitation in all cases. And he vetoed it because his reasoning was, that kind of, it takes away, it takes away really the rights of the families to say, wait a minute, I have an exception here. I have,
Right.
and it puts the parents' interest in saying, I want 50%. No, I want 50%. And what the parents' interest might be in having 50-50 or being able to say they have 50-50 versus what the child's interest might be.
Okay. And it was a whole package. You had a vote yay on the whole package.
So I have a feeling what might happen in future sessions is that
they
might come out and say, okay, we're going to do two separate, separate the proposed time sharing legislation from the proposed alimony legislation, because this alimony thing has been an issue for years. And, I don't know. I don't know if we're with the times or behind the times or what. Some people say that Florida, because if you have permanent alimony, that was devised in another time, in another era when people stayed home and didn't work, but that still exists. That still happens, that situation all the time. And especially in South Florida, you have a lot of stay-at-home moms. And so, we'll see. We'll see what happens.
You told me one time, and I want to say this because if I was listening to the show now, I would probably be wondering. You told me one time, you said, I'm not the most expensive, I'm not the cheapest.
Okay.
But a lot of people think,
that sounds right.
Well, because you said that, some people might think because, you're certified that you're at the top of the scale.
Yeah,
and I don't want them to think that.
No, well, thank you. Okay. Yeah, and I'm not at the top. I would say I'm in the median range, or even, if you ask some people, they might say the lower range of hourly rates, even though I will tell you this, even the lower range of hourly rates for a divorce attorney, and we charge hourly rates because it's based on the time that we spend. Yes, I've been told I'm on the lower end, but it's still very expensive in relative terms.
Especially if there's a lot of assets involved.
Yeah, and if there's a lot of assets, if there are children, if there are child custody issues, or someone's disputing that, lawyers charge for their time, and the time can add up. Yeah, the time can add up depending on what the issues are, depending on how disputed the issues are, or if you have, some one or both parties can be unreasonable, irrational, illogical, and just litigate from emotion instead of trying to be calmer, as they maybe should. But, when you're dealing with people's families and their children and their lives, and, it's understandable that a lot of people litigate from a place of emotion. So
I'm going to say this because I used to hear so many women mostly, not men. My lawyer did a horrible job for me. Now, understand, you've probably got a budget for this, but there's certain times you just don't want you need to spend the money, or you're going to be like these people are, my lawyer did horrible for me. See, this is all you do. I mean, there's lawyers out there who have shingles that are mile long.
Yeah, I know. And I don't know. It depends. I typically tell people, and I would advise people, that if you're going to go through this process and you're seeking an attorney, you should seek someone that only practices this area of the law. That's just based on my experience, my observation, and my own experience in the field, my own expertise. Yeah, I think that it's a very intricate area of the law. There are a lot of pieces to it. So when you go to a divorce trial, Think of it. If you have a lawsuit, a slip and fall, or a some other civil matter, you're going to trial over that. There's one issue: how much are the damages? What's the number? You go to a divorce trial, you have maybe there are 20 different assets to divide: properties, retirement accounts, bank accounts, brokerage accounts, forthcoming pensions, annuities, stock options, all kinds of different things. And that's just the assets. Then you have, is this an alimony case? How much is the alimony? What are the respective financial positions of the parties? And what are the other factors that contribute to an award of alimony or not? You have child custody issues and all the things that go into that. And if you have a complex custody case, you could have, some sort of social investigator, a guardian ad litem, experts coming in to testify, other witnesses coming in to testify. And so, divorce trials can go on for quite a while, a matter
There's
of days.
asset forensics,
and forensic accountants if you have complex assets. And,
or you might think that your husband's hiding some of the money.
Yeah. So we have absolutely. We have third parties come in and testify, and you may have 15 different witnesses to come in and support your case, and that's just your side of the case. So, a lawyer litigating all those things and preparing that case.
No, it takes a lot of hours.
There's a lot to do, but there are a lot of issues to know, and there are a lot of things to know that surround that. So it's a very, like I said, my word is intricate area of the law where there are just so many things to know, and it's just really better to hire someone that does only family law.
Give everybody your phone number and your website. You got a great website.
Oh, thank you. Sure. The phone number is 561-544-6861. And the website's www.lewertlaw.com. And Lewert spelled Lewert.
Well, I've got, you told me, so there's no way we can get through all these questions.
I know, I saw the list.
Yeah, it's like 2 pages, but I went back for about the last 7 or 8 months. And here's one. What kinds of assets are divided in a dissolution matter, which is divorce? Mm-hmm. What kinds of assets are divided?
All assets. So and sometimes it's interesting. People don't always think of certain things as assets. So everything from, like we talked about, the basics. Bank accounts, retirement accounts. Even retirement accounts are typically, say you have a 401k. That's in your name only,
right?
Because you're the employee earning and contributing to the 401k. A lot of people don't know that is an asset to be divided in a divorce.
That still goes in the middle of the table.
It still goes in the middle of the table. So even though it's in your name and you were the employee and you're the one who worked and contributed to the 401k and your employer matched or whatever they did, it's still whatever was contributed to that 401k during the marriage is still presumptively 50-50. It's a marital asset and therefore divisible by half. So. The other spouse would be entitled to half of it. But other things like businesses, a business interest, any business interest you have, whether it's, a professional practice, a law practice, or a medical practice, or some other small business, a franchise, or a corporate or shareholder interest in some other business entity. Those things are also valued and
they should be.
Yeah, and not necessarily that you're going to break up the person's business, but right. If it has a value of X, the other spouse is going to be entitled to half the value of X. So half of so they're and we have to do credits and offsets for so whatever everybody's walking away with. If she's getting the house and he's getting this other property and she's they're dividing this bank account in half, and you try to look at what everybody's walking away with and try to make it about 50-50. And if one person has to transfer funds from somewhere to make sure to equalize, to make sure that the division is 50-50, then that's what the courts will do. So
jewelry. Does jewelry go into the pot too?
Yeah, I was just about to say, actually, personal property, jewelry.
Your husband bought you a Rolex, but that goes into the property.
Correct. So
okay.
So anything gifts between the parties, whatever jewelry, or as long as, again, we're talking about things acquired during the marriage.
Right. Exactly.
So if you came into the marriage with something, and especially something like that, some item of personal property, a collectible, some kind of inheritance, some antique, something like that, a piece of artwork. Those things are going to go with the spouse typically who had them, unless they somehow agree otherwise. But anything acquired during the marriage like that is valued and becomes part of the marital estate, we call it. And that marital estate.
What do you do when sometimes the other side said, "Oh no, I had that way before the marriage"?
And the other person said, "No, I just got it for you yesterday."
What do you do with that?
You have to go back and dig for whatever evidence you can find. If you can get, receipts or go back and, worst case, I've seen affidavits from the seller, I mean, things like that. And sometimes you can get those things, and it depends how remote in time. Sometimes you can't get those things. And so, but I will tell you, those items are mostly resolved and not taken before the courts. The judges get really, honestly, they get kind of annoyed when people take personal property disputes in front of them. I mean, they don't want to deal with that. They don't want to divide up your dishes and your pots and pans and say who gets what, and unless it were like a really, really significant item of value.
Hey, I love my Cuisinart.
Yeah.
We're going to go to break. This time just goes by so fast. We're going to go to break. We're here with attorney Tina Lewert. And when we come back, I've got more questions for you. We'll be right back.
I've got more answers.
Lewert Law Offices is proud to be the family law expert on the Ask the Expert show. Attorney Tina Lewert is a board-certified specialist in marital and family law. Attorney Lewert is committed to obtaining the best resolution for your divorce or other family law case by consistently providing skilled representation, expert legal advice, and personal attention. Attorney Lewert has developed an excellent reputation for providing effective divorce and family law representation in Boca Raton and the surrounding communities. Lewert Law Offices offers legal advice and representation in a wide range of family law matters, including divorce, child custody, time sharing and visitation, child support, alimony, complex asset distribution, post-judgment modifications, and paternity actions. For expert representation in all aspects of divorce and family law, contact attorney Tina Lewert today at 561-544-6861 or visit www.lewertlaw.com.
We're back. We were just talking about, Renee and I were nominated top 5 AM radio personalities for New Times. So go to New Times, their website, and vote for us.
Congratulations.
Pretty cool. I've got so many great questions here. How is child support, this is from Gabby, how is child support and alimony enforced?
Enforced? That's a very good question.
I guess they're not getting their alimony.
Or something, yeah. So child support and alimony are both enforceable by what we call the court's powers of contempt. So if there's a child support order in place or an order for someone to pay alimony and it's not getting paid, the recipient can file what we call a motion for contempt. I usually do a motion for contempt / enforcement, because contempt means that the person not paying was willful or reckless in their non-payment. In other words, that they had the money, they had the ability to pay, they could have paid, but they just didn't.
Okay.
And so if on a lesser sort of enforcement level, if the court were to find that they really couldn't pay, their pockets were empty, and yes, there's a court order. The court can't change the order just on a motion for contempt. They can't. Their hands are tied. Their court is still bound by that previous order, so they have to enforce it. And there are different ways they can come up with it, with ways to enforce it. They can find, where does this person have any money? Can they sell something? Do they have any assets at all? They have to come up with something to pay off some balance toward what's owed, and then, make a payment plan toward for paying it in addition to the ongoing payment that's already due. So that they'll enter an order. You have to set a hearing on that, and
that's the only way the courts will know is if you
correct. Yeah, and it's funny. I have a lot of people that will say, "Oh, like the court never did. He didn't pay, and the court never did anything." Well, you have to file a motion. You have to come back. You have to file a motion, and you have to set it for hearing. And it is an evidentiary hearing, what we call an evidentiary hearing, which is the equivalent of what I call a mini trial. So meaning there's going to be testimony, there's going to be evidence. So yeah, if you're the person who is seeking the child support or alimony, the enforcement of those things, you're going to go in and you're going to testify and say, here's the court order, and this is what the person's supposed to pay, and they didn't pay, and and then the defense for the person not paying is going to be usually that they don't have it. That's typically
let's say
but they need to pay it. It doesn't go away. It's due.
You can't declare bankruptcy.
Not
with
for
child
alimony.
support.
Correct.
Good. That's good. I'm glad.
Yeah.
Because we're talking about kids now.
Yeah, and there are all kinds of ways that it can be paid or will be paid, or the court can enforce it. I mean, I've seen the state of Florida garnish personal injury settlements. Somebody had a car accident, they have money coming, and they get wind of it. They will take they'll get their share to pay the child support obligee, the person who is owed child support, before the person gets their money for their injuries in a car accident. I've seen that happen.
You can lose your driver's license, can't you?
Yeah, you can lose your driver's license. There are other licenses too. I mean, there's statutes where if you have, again, things you have to ask the court to do and be a little creative sometimes. But if you have like a, some other sort of license or contractor's license and things like that, they can suspend. They can take those give those remedies to a person who's not getting their support.
This is from Stephen. Can the amount of child support or alimony be changed?
Yes, child support is always modifiable, and
it's
that's
based on what you make.
It's based on what you. Right? Yeah, the primary factor is both parties' incomes, and so it's based on what both parties earn. It's also based on the number of overnights that each party has per year with the child or children, and there are some other things that go into it. They go into the equation, but we have an equation for child support, so it can be changed. Yes, so if somebody loses a job, or somebody gets a job making 10 times more than they were making before. Yeah, and the child benefits from that. Yeah, it can go up and
not
go
just
down. Absolutely, and so because it's the children's interest, and so that can always be modified to benefit them. They have an interest in that, and so it can always be modified. Alimony, I will say this: alimony is modifiable with the exception of where the parties enter into an agreement that says alimony is non-modifiable.
You can do that.
I've seen that. Yeah, personally, I'm not in love with that. I don't advise that typically.
People do lose jobs
because if you have an agreement, and sometimes it has to do. That's done only in settlement and only by agreement of the parties. It's never done by the court. If you go to trial and you have an alimony situation, alimony case, the judge is never going to make alimony non-modifiable. He or she cannot by law, but you can do it for purposes of settlement. For some reason, one reason or another, it may be attractive to one party or something. But the problem is where you have a situation, I agreed to non-modifiable alimony and I became disabled, or I lost my job, or I went bankrupt or something, or my business is failing. You're out of luck. I mean, and non-modifiable means non-modifiable, and there's case law that says that. So it's,
I love this question because I just saw it on TV the other night. How does the court decide if a parent may relocate?
If a parent may relocate. And I've had a lot of these cases, and I've taken a number of them to trial, and I've represented both parties. I've represented.
So you actually go to trial?
You actually go to trial. You actually go to trial. You can also, some of these cases we appoint a guardian ad litem to make recommendations about what's in the best interest of the children. So Florida has a statute. We call it the parental relocation statute. It's 61.13001.
That's what I thought it was.
Yeah, that's what I knew you thought. Yeah, but it's basically what it says is that a person who wants to relocate with minor children, if you want to relocate on your own without the children, you can go wherever you want. But if you want to take the children, a minor child with you, and move more than 50 miles away from your principal place of residence, you have to petition the court. You have to file a petition.
Maybe you got a better job offer.
Usually, in my experience, it stems from finances. So that's what I see a lot. Because the test is, the question is the move, is a relocation in the best interest of the child?
Which it should be.
And usually it stems from finances, because what happens to you trickles down to your child, obviously.
Exactly.
So I've seen cases where, listen, it's hard sometimes to live in Boca Raton.
Yeah.
It's hard, and it's the job market, has not been great. Especially in certain industries. And so, I've had people that say, listen, I have a job in another part of the country. I've done cases where, people relocating to Wyoming, to California. And it's, or even overseas, actually, I've done those too. So but it has to be more than just, I got a better job. Like, in other words, you have to show that it's the move is in the best interest of the child, but also really that, is it better there than it is here? Like, and have you tried here? Have you really tried and you really couldn't make it work? I have some people that, will have, they'll come to court, and the judge wants to hear anything and everything, all the reasons, not just your job, but you want to say, not only do I have a great job, but I have family there. I'm moving closer to my family so that the children are going to be able to see their cousins and aunts and uncles or grandparents or whatever. Or I have the help. I have childcare help from a family member, so I don't have to pay for childcare. Here, I have no one. I have to pay for childcare. There, I have my mother who's home every day, and she can watch them after school. And so, so I have that added help or emotional support. So all those things, it's really a cumulative thing. It's not any one factor, and the statute has a lot of different factors and lists a lot of different elements that the court can consider in determining, what's in the child's best interest. And so, they kind of look at anything and everything. Even sometimes we have, people who, if there is a job, I will usually have my clients, I'll say, we need to get your prospective employer who made this job offer to you to testify. So we may get them on the phone to testify by phone, what the job is, how much it's going to pay, how long is the offer open for, what the benefits are, things like that. And also, schools, crime rates, anything and everything about the new location that you can.
So I might come to you saying, I need help, I have to relocate.
Mm-hmm.
But after your meeting, they might find out that the judge probably not going to allow it.
I don't know. I've had them granted. And, it also comes down sometimes to what's going on here. Is the other parent, sometimes if there's a child support issue or the other parent, how involved is the other parent? Because that's the court's bottom line concern is this move going to interfere with the parent, who's staying here, with that parent's relationship.
The other parent, yes.
And so, you have people that are involved. They're like, I want to go to my kids' soccer games and dance recitals during the week, and other parents who are like, they're not around and they're not really as involved. And so, those are the cases where maybe it's a little easier to determine that a relocation is a good idea. So, it's interesting, but you never know what's going to happen with those.
This is why you need an attorney who knows what they're doing. Listen, it might get a little expensive, but I think it actually would save you money in the long run, knowing everything up front. So it's already been, I can't believe it's already 6 o'clock already. Please give everybody your phone number and your website again.
Sure, thanks. It's 561-544-6861, and the website is www.lewertlaw.com, spelled Lewert, lewertlaw.com.
Well, I tell you what, if I ever had to get a divorce again, I am telling you, I would
hopefully you
come
don't
right
ever
to your
again.
office because you explain things so well, which is important.
Thank you.
And I know you can be a bulldog in court.
You think? Who told you that?
Yeah.
Who said that?
Tina Lewert, attorney.
I never said
No, I said it. She'll be back with us again next month, and I think we're going to start taking phone calls too. So we'll see you, though, next week. Thanks for tuning in. Peace and love. We're out.
Thanks for tuning in today to the Ask the Expert Show with Steve-O and Renee. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show.